A couple more cases that I'm sure you are intensely following. The Calais case involving the Voting Rights Act, and then, of course, there were just arguments on mail-in voting. Can you break down those cases for us and what you're looking for from the court on both of those?
So the mail voting case I'll start with, it's easier in some ways. 30 states, including Mississippi and a bunch of other red states, allow for the counting of mail ballots that come in shortly after the election, as long as they were mailed by the election. There are different ways to tell, postmarks are the most obvious way, but the USPS also scans incoming mail. Basically, the states say, look, if it was sent by election day, we think it should count. It's not the voter's fault that it didn't come in on time. A bunch of Republicans are asking the Supreme Court to strike down all 30 states' laws and prohibit the counting of any mail ballots that come in after election day. And that is a really, really, really big threat to the 2026 midterms, because we know that hundreds of thousands of these ballots get counted every election cycle. In 2024, it was more than 750,000 mail ballots came in right after election day and were still counted. So this ruling, if the Supreme Court takes up the invitation, would disenfranchise many, many, many people. It would also disproportionately hurt military voters and overseas voters whose ballots sometimes take a long time to cross the ocean and who are actually protected under a special federal statute that's designed to ensure that their ballots still count. I don't know where the Supreme Court's going to land on that, because the justices seemed really divided. I think that the Chief Justice and Barrett, again, the two key players in so many of these cases, they seemed a little skeptical because Congress has never actually passed any law that directly addresses late ballots. Republicans have proposed them. Congress has never enacted them. The idea, the sort of theory is that, well, we have an election day, right? It's the first Tuesday after the first Monday in November. And implicit in having one election day is that every single ballot has to come in by then. But as the chief pointed out, if that's true, then how are we allowed to have early voting? Because if we only have one election day, how are people allowed to cast their ballots for weeks or months before then? And I don't think that the court wants to strike down all early voting as well. So I think there's a chance the court could step back from the ledge there. But Calais, the Voting Rights Act case, is an even bigger threat, and it's one I'm extraordinarily pessimistic about. This is an effort to essentially kneecap what remains of the Voting Rights Act. The Supreme Court has already, destroyed many different provisions of it by this point. Right. But this involves the ban on racial gerrymandering, the requirement that states protect the political power of racial minorities, that states do not carve Black and brown communities into oblivion through redistricting, that makes sure they can never actually elect their preferred representative. That's been on the books for decades. It's served our country very well. It has ensured that states like Alabama, Mississippi, Florida, Georgia are sending representatives of color to Congress, that the Black and brown communities in those states are able to band together and elect their preferred representatives. And in this case, the Supreme Court is very likely to just make all of that stop. I'm not sure exactly what the court will do. I don't know if it will strike down part of the statute, if it'll sort of reinterpret part of the statute, if it'll say that it's a violation of equal protection to protect Black voting rights. Whatever rationale the court decides, it's going to essentially declare open season on Black and brown communities in red states. And the best estimates show that it will allow Republicans to draw themselves something like 15 to 19 more seats in the House of Representatives by just shamelessly dividing up these minority communities, mostly in the South, and ensuring that their votes don't count. So that's going to be just an atomic bomb of a ruling. And it's probably too late to affect 2026, but it may well be the most important factor in the 2028 race for control of the House of Representatives.
And you've talked a lot about Chief Justice John Roberts, and he is clearly a very skilled politician. He's very good at getting those serious articles written about him, about how he's so thoughtful and an institutionalist, and that he wants to preserve the court's independence. But when it comes to the issue of voting rights, this seems to be his passion project to go after the Voting Rights Act. I believe it was 2013 with the Shelby County case that decimated a large part of the Voting Rights Act when he was, of course, still Chief Justice. But long before, in his career, this has been an issue that he has paid extraordinary attention to, and clearly is not convinced, does not believe that this needs to exist. So you don't have that stopgap with voting rights. Do we have any sense from Amy Coney Barrett that she might be any more persuaded by the arguments to keep Article 2 in place?
I don't think that Barrett's in play here. I think that she is also really, really hostile to voting rights. And so are Thomas and Gorsuch and lately Kavanaugh as well. And I think, what's so disturbing to me about this case, other than their nonsensical claim that it's racist to protect Black voting rights, which is basically the argument being made by the plaintiffs, who are white voters who say that, these Black people shouldn't have so many voting rights. It's hurting us as white people. That's ridiculous. The outcome will be devastating. But what bothers me is that this is not a case where people are just going to the court asking for protection, right? Asking the court to make up some doctrine or reinterpret some constitutional provision to protect them. This is a case in which Congress did its job, right? Congress came in and legislated under the 14th Amendment a vast and broad protection for the voting rights of minorities, as it is constitutionally empowered to do. And the people's representatives, the people, who sent all of these representatives and senators to Congress, they are having their voices shut out by this case trying to dismantle the Voting Rights Act. They are seeing democracy eroded by unelected justices who don't have any democratic accountability themselves, right? This is a case in which the Supreme Court seems eager to prevent the people's representatives, prevent Congress from enacting legislation to address ills that Congress views as a serious problem still, right? Because Congress could repeal the Voting Rights Act anytime it wants. Congress could come in and rewrite Section 2, rewrite other parts of the law, take away the law altogether. But this is a case that asks the court to do that instead. And I think that is a dangerous step toward judicial supremacy and what some call juristocracy, sort of rule by judges, that seriously undermines our ability to think of ourselves as a democracy, because it's the court saying what the people want doesn't matter. All that matters is what 5 or 6 justices think the law should be.
Right. And of course, members of Congress have to take a tough vote that they might be accountable for. Obviously, 9 Supreme Court justices never have to face the public in that way.
Exactly right. And it's an odd quirk of our system that I think has empowered the justices to push in a dangerous direction that is not supported by a majority of the country. I would file in the same category the campaign finance cases, right? Striking down laws that Congress enacted, right, pursuant to popular demand by the people to try to restrict the corrupting effects of money in politics. But the Supreme Court just strikes them down, and the Supreme Court never has to worry about losing their jobs because of it.
Right. And I can't help but think about the fact that the courts and the Supreme Court in particular have been such a focus for far-right groups for a long time. They identify the fact that, if you can capture enough of these, critical courts, and especially the Supreme Court itself, that is often easier than flipping a chamber of Congress. And when they're making such consequential decisions like this, from a purely political standpoint, that is a very wise strategy. But certainly, I don't think that this is what the founders intended with their separation of powers and how they expected that we would be carrying out their vision, 250 years in. Talk with us a little bit more about how we might try and restore some of this balance of power, because we see that the executive branch has expanded its power especially the president himself. The court's power has expanded. And then we've seen that this Congress has really willingly given up so much power. How does this work, and how can we get back to more of a balance?
Yeah, I mean, I think that the answer here usually begins with Congress actually reasserting its role, right? And that would be especially helpful right now because much of the powers that Trump has been seizing are legislative powers. He's been taking away powers from Congress, powers of appropriation, right? How to spend money over independent agencies. Think like the Federal Reserve, who can sit on the Federal Reserve. He's trying to interfere with all this stuff that Congress established. And so I think if Congress were able to come in and pass more robust legislation, there would be some corrective. But the deeper question would still be, well, what do we do about the Supreme Court? And I think short of direct reforms, Democrats need to get really, really savvy about writing statutes that have sort of fallback. So for instance, and this is just one example, like Congress could pass a law that expands Obamacare and expands Medicaid and does all of these things that Democrats want to do, and then have a second section that says, by the way, if the Supreme Court strikes this down, then instead we're going to have Medicare for all, and just have this kind of backup option that kicks
like
in.
a poison pill in every bill. Okay.
Yes, and there's nothing that prevents Congress from doing that, and it could have 10 backup options if it wanted. If we can't have Medicare for all, then we're going to have a public option or a single pay, like whatever, right? Congress could do that, but it hasn't because these bills are obviously the result of like very careful compromise. But I think this should be part of the conversation when legislators are drafting their work, because anything Democrats pass, this is the reality, anything they pass stands a decent chance of being struck down by the Supreme Court. That's just the way that it works. The other thing I would say, and this is kind of tied in, is that Democrats need to put a time limit on judicial review for their statutes. So, the problem with the Supreme Court having total control over its own docket, one of the problems is that they can basically wait until Democrats lose control of Congress or one chamber of Congress and then strike down a law, right? They almost did that with Obamacare, right? The Obamacare decision came down in 2012. Democrats had lost control of the House after 2010. And so if the Supreme Court had struck down all of Obamacare, then there wouldn't have been anything for Congress to do because Republicans controlled the House. And they, even then, the Supreme Court really dismantled a lot of the Medicaid expansion in that law. Democrats didn't have the power to try to patch that hole. And so I think the Democrats need to start putting like a serious time limit on this stuff and saying that, if this has not been reviewed by the Supreme Court and a decision hasn't come down within 12 months, the Supreme Court loses jurisdiction over the case, and that's the end of it, which is something that Congress, at least in theory, does have the power to do. Congress can decide what jurisdiction the Supreme Court has, what questions it can answer, what questions it cannot answer. And so this stuff, it's a little technical, right? I know it's kind of technocratic, but it's also low-hanging fruit and worth a try, because the Supreme Court has so many tricks that it can play to try to kind of prevent Democrats from passing enduring legislation. I think if Congress passed Obamacare today, it wouldn't survive the Supreme Court. And so there are ways that Democrats can try to circumvent this and remind the Supreme Court that it needs to stay in its own lane. And then I think if Congress does try that and the Supreme Court doesn't listen, that's the point at which Democrats have to say, we've tried it. It didn't work. Now it's time to expand the court, because everything short of court expansion, it just doesn't work because the Supreme Court still holds too many cards.